This hearing is in the matter of CFI 0472019 before Justice Roger Giles and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on Justice Roger Giles's instructions. The claimant is represented by Hadef and Partners. Lead counsel is Tom Roscoe. The defendants are not present.
All right. Well, Mr. Roscoe, I've read the papers and your skeleton. Thank you very much. I have a reasonable grasp of what's involved. There are, I think, a couple of matters to discuss, but I'll let you take your course in how you want to present it. But you may present it on the basis that I have read the papers and the skeleton.
I'm very grateful, Your Honour. Thank you. Yes, the other side aren't present or represented. The flavour which Your Honour will have picked up is that there seems to be a large amount of abandonment from their part, potentially for financial reasons, of further engagement with the case. We are where we are. There are two applications formally before you. The first is our 29th of November 2021 immediate judgment application. That's the substance of why we're here. There's also an alternative service application, which you may have seen is also before you. That is primarily filed out of an abundance of caution in case any point was to arise about service. I'll explain that slightly more fully in due course if I may. But the substance is the immediate judgment application. As Sharon will know, it's a claim to recover sums advanced by Caterpillar for the purchase of Caterpillar branded construction equipment, and that's over 5 loan agreements, which have then been consolidated into a amended agreement. I propose,
just a matter of interest, they're called vehicles. They look like heavy construction equipment or mining equipment of some kind. Do you know what they are?
There are 5 agreements. There are slightly different things. At one stage, my knowledge of Caterpillar vehicle codes was slightly better than it is now, but I think they're heavy excavators and things of that sort.
Yes.
They certainly some of them will have vehicle registrations. I think they do go on roads. They have license plates and are registered as vehicles. Those instructing me who are also on the call will no doubt send me a message now to with some further information should that be of assistance.
It just as a matter of interest, I would like to know what we're dealing with.
What bits of kit we're dealing with? Absolutely. Well, I'm sure that will filter through in the next few minutes. I can return to that. I was proposing to take my submissions in 4 hopefully brief parts, given the helpful indication about the pre-reading. First, say something about the procedural history and how the potential service issue arises in that context. Secondly, just to take you through the structure of the relevant loan agreements and how the debts have become due. None of that appears to be in dispute on the face of the defence. Third, I was going to take the intimated defences in turn and explain why they don't have any reasonable prospect of success. I should pause there to say that I'm taking it as read, I hope not presumptuously, that there's no other good reason for trial in this case. So it is a pure merits-based assessment at this stage, and there isn't an independent good reason for this to proceed to trial. And then finally, by way of checklist, as it were, at the end, I was going to take you on through the draft order to by way of checklist of the relief that we're seeking, and deal with costs in that context as and when we get there. So the operative claim form, as it were, Your Honour will have seen, I hope. Make sure I'm the screen juggling. Is the re-amended claim form, which is dated the 30th of February 2020, and that's at B5 of the B document 5, so page B30. I don't know where I was working on section number or page number of the electronic bundle.
I'm working on page number actually. Can you give...
Yes, B30.
Right, thank you. Yep.
So this is the re-amended claim form, and that's supported by particulars of claim, which actually slightly predate it, which are dated the 8th of January 2020, and they're at page B13.
Yeah.
Now, there's no issue as to the service of the claim form itself, because all three defendants did acknowledge service of the claim as then amended. I don't think I need to turn up the acknowledgements of service, but they're dated 20th of February 2020 as relates to the second defendant, and they're dated 5th of March 2020 as relates to the first and third defendant, and they're at pages G6 and G7.
Didn't the solicitors, didn't Canards then come on the record for them? So
The solicitors did come on the record, exactly, Your Honour, you're one step ahead of me, and the only address for service therefore given on the acknowledgements of service was the then solicitor's address, and that was the firm of Canan Advocates and Legal Consultants. And it's also perhaps relevant to note in this context that the solicitors on that acknowledgements of service included an email address, so therefore presumptuous. A presumption in favour of electronic service in accordance with the rules.
Yes.
So there's no issues with service of the claim. Then the immediate judgment application, as I've said, was issued on the 29th of November 2021, and that was served on the solicitors by email. A few weeks later, the solicitors applied to come off the record for non-payment of fees, and it may be, not that it matters, that the two events were connected, but just to make good the point, or for to see how that unfolded, it may just be worth turning up page J108.
Yep.
And you can see there at the bottom half of the page, running reverse in the thread, you can see there the 30th of November 2021 email from Ms. Lazala of My Instructing Solicitors at F & Partners to the defendants, then advocates, enclosing a sealed copy of the application and the evidence in support.
Yep.
And recording it being e-filed. And that was on the, as I said, the 30th of November 2021. And then scrolling up the page, or to the page before J107, you can see the email above in the chain is not by way of response per se, but it's in the same chain. And you can see there that that's the defendants then solicitors applying to finding attached by way of service their application to come off the record. It's 2 or 3 weeks later. And it is of some relevance to note that in this document you can see that there are, in the email header, or the list of email addresses which are involved, you can see there that there are after the two list of email addresses, you can see there are 3 email addresses there. First of which is info@omertransport.ae, which appears to correspond with the first defendant. aman@omertransport.ae, which appears to correspond to the third defendant, and Crusher Omar Transport, which appears to correspond to the second defendant.
Yeah.
So those were that was by way of service of the application to come off the record, which application was granted very promptly, I believe, in fact the following day. Contrary to the rules, however, Cannon Associates didn't provide any alternative address for service or email address for service of the defendants, nor have the defendants themselves provided an address for service in in Dubai or the DIFC. And we might briefly look at the relevant provisions, and they start with Rule 9.31. Sorry, forgive me, I've given you a false reference. 9.15, forgive me.
Well, that's not the rule that deals with it when the solicitors go off the record.
No. This is that rule refers to this one, which is why I've taken you're onto it first. So this is the starting point, and of course that had been complied with originally as regards all defendants by their solicitors giving an address for service, but then the coming off the record rule is at 37.17.
I don't think it was up to Canans to give the new address for service.
Sorry.
Up to the.
Forgive me, I hadn't meant to suggest otherwise. No, the defendants are themselves in breach of the rules and not providing any fresh address for service upon their solicitors coming off the record. Sorry, no, I hadn't meant to imply criticism of Canans in that respect.
Yeah. Right. We don't know whether Canans told them they needed to, but I don't think it matters. The fact is that they have not given them.
They haven't been quite so. So just pausing there, so there's no issue with service of the immediate judgment application itself, because that was served before them coming off the record. The only additional documents which Caterpillar has been anxious to ensure came to the defendant's attention since Canans came off the record has been notification of this hearing, and that position has been slightly complicated by the fact that this hearing had originally been listed for, I believe, the 24th of February, but the judge who was scheduled to be hearing that was unfortunately taken unwell, and so it was relisted. So there've been two hearings to notify about. Just to take this in order, at page E53.
I don't think you really need to go through that, because I have been through it.
I'm grateful.
In sum, the efforts at personal service in the sense of leaving at an address on both occasions have really not been successful. There was an email on both occasions to the addresses, which happened to be the addresses in the email to which you referred a moment ago, plus used in a few other places. The email for today's date was, if I remember rightly, the 17th of February. Whatever it is, it's just a day or two shy of 14 days.
Yes.
So to cut to the chase, the question is, was there notice in accordance with 24.6 by virtue of sending the 17th of February emails? I think that's correct, isn't it, Mr. Roscoe?
Yes, I think that's a very fair summary of the position, if I may say. Yes. Yes. And to the extent that there was a day or thereabouts short, one has to bear in mind, I submit, that was after the hearing had to be relisted at short notice.
Yes.
So yes, cutting the chase, what we're effectively asking your Honour to do is to confirm that we're regular today, to waive any such defect as there may have been, and looking forward and for service of the any order made on these proceedings or any other documents that might need to be served in these proceedings, to authorise service of those documents via those email addresses, rather than going through the rigmarole, not wanting to too pejoratively, of leaving documents at a last known place of business where it doesn't seem any business is any longer being carried out, or in the case of the second defendant trying to serve for Jerry.
I think we've really got two steps. One is whether there was appropriate notice of this hearing. The question of service of any other documents in the future, I think, is a separate matter.
Yes.
Now, presumably you put on your substituted service application, or I think here it's called an alternative service application, pardon me for using language to which I'm accustomed, in order to A, cure the first, and B, provide for the second.
Yes.
I'm not at all sure that you either need the first or indeed that there is power to do it. For the reason that Rule 24.6, which is the rule we're talking about, says that must be given 14 days notice of the date and the issues. Just check that up so you have it in front of you.
Yes, let me have it in front of me.
That's what we're talking about, I think.
Well,
Is it not?
to subdivide your two issues, I think the first may in fact have two limbs to it. The first of which is the method of service acceptable? In other words, the leaving at the office and the email. And the second issue is the period of service, the period of notice.
Yes, there's undoubtedly the period of notice, but what I would suggest to you, and it is in your favour, is that what Rule 24.6 talks about is notice, not service.
Yes.
At least according to terms of the rule, you could give notice by a phone call.
Indeed.
Service, if you look at the definition of service in the rules, it talks about, I forget the exact words, but delivery of a document required to be served by the rules.
Yes. Yes.
What we're doing.
Yes. No.
I think there's power to make that.
Yes. I entirely take the point, and it was a certainly under our English procedural rules. There's a question which wasn't I confess not altogether clear to me what the answer was, as to whether a formal notice of hearing issued by the court, as is the English court thing, is a document which is required to be served. But as Your Honour says, what one's dealing with under 24.6 is notice rather than a formal service of a formally issued notice of hearing. So I take the point that actually it's the notice point rather than service retrospectively, which is the central issue. I respectfully entirely take that point and agree with it, if I may. In terms of whether there's power to abridge, in my submission, that there must be under the court's general case management powers. Forgive me, I'm in seeking to give effect to the overriding objective of dealing with the case and proceedings justly in circumstances, just to get the chronology correct. Notice of the 24th of February hearing having been given on the 26th of January 2022. So that was well more than 14 days of the original hearing. Just may not have made absolutely clear. The original hearing had been listed for the 24th of February 2022. Notice of that hearing we see from the Shart's affidavit at E34 was done on the 26th of January 2022. So that was more than 14 days prior to the originally listed hearing of the immediate judgment application. That hearing was then vacated due to the ill health of the judge who'd been listed to hear it, and then listed for today, which, if my maths is correct, was 7 days later. And so a notice of that rearranged date was given on the 18th of February 2022. So the revised hearing date, as John has already pointed out, was a day or two short of 14 days, but the
clear days is what it is.
Sorry?
11 clear days.
11 clear days, yeah. And so there's two routes through it. Otherwise, what my submission would be a unfair and peculiar result, namely that the relisting of the hearing has not been relisted with sufficient time to allow notice under rules. One of which is to treat the vacation and relisting as an adjournment of the original hearing date, and so one treats notices have been given for the original hearing, which was then adjourned.
That won't work. But the original hearing wasn't started. The real question, and also one must look at the substance. Have the defendants been given notice of today?
Yes.
Otherwise, you couldn't fairly give judgment against them.
You're quite well. Yes, that's undoubtedly the rationale for the rules. One supposes is exactly that, to ensure that people have adequate opportunity to get representation in order and prepare to attend at a hearing to argue the points.
But why don't we again try and cut to the chase? Rule 4.2.4.21 or 4.51 seem to me to give me power to shorten the time retrospectively.
Indeed,
or say that it doesn't matter.
Indeed, Your Honour. Yes, that's the second.
That's appropriate.
Yes. Yes, and I submit in all the circumstances it is. They had more than 14 days of the first hearing. Should have been ready to go then. It was circumstances outside the party's control, which meant that hearing didn't go ahead. It's been listed for 11 clear days subsequently. They should have been ready, and by rights ought to be ready on the 24th of February.
Well, I'm not troubled by that. The question then is, were the emails notice within the meaning of the rules? What's meant by notice?
Sorry.
What is meant by notice?
Well, I think you're, as Your Honour already said, doesn't require any particularly formal service. It is bringing it to the attention of.
Yes. A means which it will bring it to their attention.
Indeed. What one sees it in the context of alternative or substituted service applications. The question is, typically in that context, the two overlap in asking whether or not the alternative means should be considered service. The question is, will it have come to the attention of the recipient?
Yes.
Not be all and end all, but that's an important fact to take into account.
Yeah, well, that was the line of thinking that I had in mind also, and I'm happy with that. I consider that there has been notice given, and I'm willing to abridge the time or say that the 11 days is enough. What is left of your application for alternative service is something for the future, which I'm frankly not inclined to enter into, because that must depend on the circumstances at the time of service of whatever the future document is.
Your Honour, to answer the question, I hope not too roundabout a way, that there is this difficulty with crops up all the while in alternative service applications, which is that under the English rules, there is expressly power to retrospectively to bless steps that have been taken by way of service. That express ability retrospectively to bless is absent from the rules of the DIFC. If I can just turn that up, as it's 9.
Why are we worried about retrospective blessing?
Well, because because when Your Honour says the question of service is one for the future, indeed so, but presumably, whatever the outcome will be, an order will be made at the conclusion of this hearing.
Yes.
And it will be the duty of the claimant to serve that order, whatever form it's made.
Not their duty. They will do so if they want to do something.
Yes, if they wish to enforce, they will have to serve it. Exactly. If there's to be a further hearing, whatever there might be, notice or service of that document will have to be given. What the rules anticipate is at 9.31 is proactively, primarily, rather than retrospectively, permitting the serving party to get clarity in advance of trying as to what they're to do, as opposed to doing their best, as it were, and then coming to the court and saying, I've done my best, but I couldn't serve via formal channels for whatever reason, retrospectively bless what I've done.
Except that you do need to know what you are trying to serve or want to serve, which at the moment we don't.
I'm not sure. I with respect entirely agree with that. If the question is not so much the steps one needs to take to draw a document to the attention of the other party to an extent that the court will be satisfied constitutes adequate service, treated as adequate service. My submission oughtn't depend on which document it is that's being served, whether it be a statement of case or an order or a notice of hearing, whatever it might be.
On the contrary, I think it does. That must be a factor in deciding whether the alternative means proposed is adequate.
To do with the magnitude or severity of the hand, for example. Yes, well, certainly I can see that if one was dealing with purely administrative matters on the one hand, as opposed to something perhaps with a penal notice or otherwise attached on the other, I can see that. Could I propose dealing with it in this way, which is that the immediate concern will be service of whatever order it is that's made at the end of the hearing?
Yeah.
And so,
well, I'm not even sure about that. What rule is it that requires service?
well, nothing requires service of the order per se, as Your Honour made clear. It's a case of whether or not.
Well, let me put it differently. What is Caterpillar going to want to do thereafter, which under the rules will require service? What are we anticipating?
May in part depend on the form of order, but they will want to take steps to enforce.
I think, Mr. Roscoe, I'm not inclined to make a general prospective alternative service order. I will stand that application over to be relisted on your application, so that when when in due course it's known that there is something to be done, it can then be asked that it be done by alternative service if that's appropriate.
Yes, very, very well. And I'm just wondering whether in the recital, whether in any order that's made today, on the order that's made today, again, this may be prejudging the issue, but the concern is often, the concern might be whether or not that relief can be sought retrospectively.
Well, that won't be a case of retrospectively. The orders will just be an order. It will be there in the ether, as it were.
Yeah, no, understood. Thank you, Robert. So that's as it were the procedural aspect, and I think that's probably clear enough. I think I understand where we are on the point about alternative service, and certainly the important thing, which I think we're there for immediate purposes, is are we effective now? And that bit certainly has.
Procedurally, we're okay now, and we get to the substance.
And if there are further procedural matters, we'll deal with that in the future. Thank you. So then, to turn then to the to the substance, as set out in the particulars claim by Skeleton, there are 5 underlying loan agreements, all of which are in, save for the amounts and the particular vehicles in question, in materially the same form. You asked about the particular vehicles, and now maybe a convenient way to do it. I've been sent a screenshot of some images of what they are, and they are maybe letting my construction knowledge down here, but bulldozers / heavy excavators.
Yeah.
So they're vehicles in the sense of being wheeled or tracked.
Yes.
Vehicles.
Yes. Yeah, I assume there'd be something of that kind.
I was going to say JCB, but I'm not sure if that's a trademark of somebody else or my client's group, but probably isn't.
Basically, it's someone else. So.
Yes. Anyway, that's that sort of thing. Large and yellow is about the extent of my technical abilities on that, I'm afraid. So the 5 security agreements, as I said, are in the same form. I'll just briefly take your honour through one set of them, the underlying agreements, and that starts at page C28.
I have one printed off, which is for vehicle 966.
966, let's see if I can find that one, so we're on the same page.
I think it is C9, or oh no, sorry, this is taken from the claim form, I beg your pardon. So
966, you're quite right, it is C9, thank you.
Yeah.
And you'll see the way these agreements work is that they start with what's called a schedule, which is slightly counterintuitive, but it fits together well explained. Schedule 1 is the sets out the particular model which we're dealing with. This is a model 966, so some form of excavator, and it has the US purchase price for that vehicle. You can see at the top, possibly I should have started with this, that the legal, the customer's name, it's both the first and the second defendant as joint customers here, and the model number, the price is set out, and then you see that the way the financing plan works is that to that purchase price is added a applicable rate, in other words, a finance fee, which is calculated by reference to the period over which the facility, or it's not a facility, but the period over which the balance is going to be paid in instalments, and an arrangement fee which gives you a total amount of to be paid. In this case, it's $307,000 odd, and then that's to be repaid in 36 monthly instalments of $8,500 odd. And so it's not a loan on which interest runs. The finance fee or the interest fee is calculated as a lump sum and added to the amount which is treated as being outstanding in the first place. So that's the headline figure under this agreement, and as I say, there are 4 other agreements in the same structure. You then see at Schedule 2 what's described as a promissory note, but which is a acknowledgement and agreement of the amount of the outstanding debt and the obligation to repay it in 36 monthly instalments. And you see there it's some small import perhaps, that the payments are required to be made in US dollars, reference to AED is for convenience only, but it's an obligation to pay in dollars. Yep. Schedule 3 then confirms and acknowledges that a mortgage has been taken over the vehicles being advanced to be registered in the name of Caterpillar security agent Mohammed Al-Bahar. Then next one gets at C12 the terms and conditions which cover the whole agreement between lender and borrower. Just a few points to flag on that. 3.1 is the promise to pay the amount set out on the schedule we've looked at. Four requires deals with interest. Although that's, as I've already indicated, that's something of a misnomer, because what's there being referred to is actually in a way duplicative of the agreement to pay the amounts, because the interest on the amount financed at the applicable rate has already been wrapped up into what the total of payments are under the monthly instalments.
Yeah. The relevant interest provision is 3.3, isn't it? It's the default.
Sorry, I just glossed over that. Absolutely right, exactly. So there are 2 interests. There's the rolled up interest financing fee, which is actually on the balance of payments already, and that's to be paid by way of monthly instalments. It's not actually a separate interest rate at all, really. And then your honour's picked up, in the event of default, there is then a default rate which applies on top to any amounts outstanding.
Yeah.
And so, while we're there, and you can see 3.5 is the grant of the mortgage over the vehicles.
Yep.
5 requires reimbursement for any cost, fees and expenses, and indemnity against cost, fees and expenses. 5.2. Clause 9 then sets out various events of default. Events that will be deemed an event of default, including, most relevantly at A, failure fully and punctually to perform or observe any of the terms of the agreement, and C, failure to make full payment for a period exceeding 7 days. And then at 9.2 and 9.3 set out the consequence of there being an event of default. And effectively 9.2b, the middle of the paragraph there, operates by way of acceleration.
Clause, yes.
And 9.3 requires delivery back of the vehicles over which security grant and finance has been taken out of respect of in that event. Clause 10 sets out what might be described as a sort of manifest error clause, which is that Caterpillar's records are conclusive, absent as a matter of law, manifest error or fraud.
It doesn't actually say that. It is in terms a conclusive evidence clause.
It is in terms one. I accept that that must be, as a matter of law, subject to a manifest fraud or manifest error or fraud carve out.
I was going to ask whether under English law there is that implied carve out. I wanted to seek your assistance on that.
The reason I pause is that certainly as a matter of English law, it wouldn't be effective if it wasn't read as such.
Right, but then the question is why? Because there was a question about whether a conclusive evidence clause was valid and enforceable. Under Australian law, the answer is yes, according to the High Court. But I don't know what English law is on the point.
Sorry, the Australian authority, Your Honour, has in mind. You said that was a conclusive.
Yes, Dobson and National Bank is the case.
It's a conclusive evidence clause was
conclusive.
Was conclusive. I should say, by the way, that this is a DIFC law agreement rather than an English law agreement.
Yeah, well, we could have a debate about what that means. What is
yes,
does that mean one goes through the cascade, and if there is no applicable DIFC law, no decree, I'm certainly not aware of one in this area, we default to English law.
This very clause was considered by Justice Al-Sawari on a Caterpillar and National Golf case, which is included in the bundle because it's touched on the very same thing. I don't know if Your Honour's had an opportunity to read that decision.
I've read that, and I've looked at the decisions that His Excellency relied on, and with respect, I don't think they support what he said, because the decisions he relied on for saying that this clause was effective subject to manifest error, the decisions he relied on were all clauses which actually said in terms subject to manifest error. So I have some difficulty with treating what His Excellency said as authoritative.
I see. Well, yes, I see the point of distinction. I think what I would say is given the Australian line of thinking, and I confess I haven't thought about the point of research, the point of matter of English law. I confess that, but the Australian authority Your Honour's got in mind would be a higher point of the case than I need it to be, and so.
Why?
Well, in that I've advanced the position that I accept that manifest error or fraud would be a way around this clause, but there isn't any suggestion of fraud nor manifest error, and so.
Except what if the English position was that a clause expressed in these terms is invalid and unenforceable rather than subject to some qualification by reference to manifest error? In other words, if you reach for too much in your agreement, you get nothing.
The answer to that, if that were the position, as a matter of DIFC law, putting aside the cascade point for the moment, but would be clause 12, which is partial invalidity clause.
Well, sorry. All that means is that clause 10 is scrubbed out. You don't have a any conclusive evidence or even partially conclusive evidence clause at all.
It would be deemed ineffective only to the extent of such illegality, invalidity, or enforceability. And
Yeah.
so, if the extent of the conclusive evidence clause was as to was to invalidate it to the extent that it sought to be conclusive, even in the case of manifest error or fraud, it would be invalid to that extent, but valid.
Well,
valid to all other extents.
Well, I'm not sure that's how clause 12 works. Anyway, look, let's just go back. Number one, I could be satisfied on the evidence that the calculation is correct. So you may not need this clause. Number two, you may want something said about it in case it assists at a later stage, provided, of course, what is said is in your favour. So if you do want me to deal with the conclusive evidence clause, I'm going to need some more assistance from you to find out what the status of a clause in these terms or terms to these effect, that is a conclusive evidence clause, is effective or not. Is it effective according to its terms? Is it ineffective because it asks for too much? Or is it effective but subject to an implied qualification? So if you want me to deal with that, I'm going to need you to ask you to do a little more research and help you on it.
You're on it, yes. And I can apologise for not being in a position to deal with it now. I'm very grateful for that way of dealing with it. If I may take instructions will come through to me as no doubt, or maybe take a pause at one stage to get them. But if Your Honour would be willing for to grant the indulgence of a short note after the conclusion of this hearing on that point, should we wish a determination of it, I think that would be that much appreciated as a way forward.
Yes, I should say that I think I'm satisfied that simply on the evidence, as a matter of calculation from the evidence of the gentleman whose name I can't remember, the figures are, I would accept the figures, but you may want for future purposes something more.
And certainly in light of what's said, what Your Honour said about the earlier judgment, I quite accept the point of distinction. May I just make a note again of the Australian case to which you refer to? DOBBS. Yes.
National Bank is a decision of the High Court very many years ago. I think that it is still regarded as good law in Australia. There may be statutory qualifications, I'm not sure. So that may be an avenue into your research.
I'm most grateful, thank you. So that was clause 10. So if we return to the terms and conditions, I don't think there's anything more I need to take Your Honour to in the terms and conditions. We then have
18 about repossession, presumably.
Yes, sorry, yes, which is the corollary of the point about the events of default, which we looked at a moment ago, about in the event of that default, they're obliged to deliver them to us. There's then a privacy statement which we need to concern ourselves with, and then there's the personal guarantee of Mr. Backey, which starts at C23. And a point is taken in the defence about the need for demand.
Yeah, well, let me say that I am troubled at this here point. So let's put it aside just for the moment. Deal with the other points. One of the points is calculation of amount. I think as I said, I think I'm content with the evidence as to the amount, although I can see reasons why you might wish to have the conclusive evidence clause in your favour if it is.
Yes.
The second is about the interest rate. Now, it's a little obscure just what they're saying about that to me. So give me your submissions on that. And then I think the remaining point is the guarantee point, is it not?
There's the for me to submit slightly obscure point about the whether the possession claim is properly a matter for the local court.
Yes, that is right. I don't. I've read your submission on that. I don't think we need to trouble further about that.
Very well. Well, let's then deal with the first two points, which should deal with the corporate defendants, and that clears them off, as it were. The evidence of the amounts is summarised, I hope helpfully, in Mr. Abdul Hafiz's statement, which starts at page A39, and he summarises the defendant's position and explains why we think it's wrong. Page A45 and following, and to boil it down, the point that's made is that the difference in the figures appears to be almost exactly the round sum of 100,000 AED, which might just be a typographical error, but we've checked our figures, we've identified a £10,000 discrepancy which has been corrected, and we can't assist further than to say this is what we think the figure is. We don't know any more than that. And in the absence of any evidence in response to the immediate judgment application, we simply invite your Honour to find that there's no reasonable prospect of them persuading you otherwise.
The point is that the defence, because it speaks in terms of Durham and is subject to whatever conversion rates we use at the time, really doesn't provide any true basis for doubting the figures.
No, it could be a conversion issue from time to time, with what rate that's being used from time to time. Who knows what the evidence is, but I'm at risk of arguing against myself here. But yes, entirely.
I think we can move on.
Thank you. So then there's the question of contractual interest, and 2 points are taken. 2 or potentially 3 points are taken about this. If we may be helpful to turn up the defence to see them. It starts at page B38.
I have that in front of me.
Thank you. And it's paragraph 20 is the section on this. The first point is to refer to the Practice Direction 4 of 27, interest on judgments, which referred to a 9% rate, and trying to say that is of some application. Simply say it isn't, because we're not seeking judgment interest, we're seeking contractual interest. So it's just nothing to the point.
Well, the curiosity is that paragraphs 20 to 24 end up with saying that interest should be at 9% from the date a judgment is issued.
Yes.
That does not appear to be addressing the interest, the rate at which interest was charged in calculating the claim.
Right.
Whereas paragraphs 25 to 29, although they're expressed to be in the alternative, would appear to be intended to deal with the interest rate charged under the agreement.
Indeed.
Which is rather strange in the sense that it's expressed to be in the alternative. Maybe the answer is that paragraphs 20 to 24 were also meant to be interest rate under the agreement.
Potentially.
So I think we need to look at them on both.
Well, but I suppose you deal with it on both, but on both bases. I said they're both bad points, and so whether one takes them collectively or in the alternative doesn't, in my submission, make any odds. But you made the point that we're not dealing with interest on judgment, so that seems to be a red herring for the purposes of my client's claim. The alternative argument or concurrent arguments that may be about law of damages and remedies, simply say my submission can't exclude what the parties have actually agreed. The Article 17 as set out there refers to a failure to pay sums when they fall due. Well, contractual interest is a sum which falls due because it's been agreed to be paid. A question might arise as to whether or not Article 17 would apply to the failure to pay contractual interest. In other words, whether one gets a sort of compounding. You've not paid, or on the principal amount in addition. I might have pleaded the case to say you haven't paid the principal amount when it fell due on the event of default, and you haven't paid the contractual interest which is due. I'm therefore entitled to 9%, sorry, to 1% above IBOR on top of those sums. Had I put it on that basis, there might have been a question as to if that's appropriate and whether or not contractual interest bars relief under Article 17 at the same time or on the same sums. But I've not sought that. So I'm not seeking any further or additional relief under Article 17. I struggle to understand the argument that Article 17 serves to exclude contractual interest provisions.
Yes, well, it seems to me that I think that is right. I don't think you need to address me further on it. And your point about paragraphs 20 to 24 is simply that the contractually agreed interest rate is agreed, and it's not a question of the judge just prescribing any other rate.
The final point under this, I don't wish to say anything further about this. The final point under interest is there's a sort of tentative suggestion at 21 that the rate's somehow excessive. It's not altogether clear whether that is meant as a freestanding point, aside from it being said it's above the 9% rate or the 1% IBOR rate which are dealt with. But I don't understand, well, to the extent it's a freestanding point that somehow the 18% shouldn't be allowed because it is excessive. I'd also ask Your Honour to find that that's a point that has no real prospects of success. No.
The question would be, by what measure? What is there that, according to DIFC law, whatever that may be, provides a measure according to which you say it's excessive? Is there anything that, I suppose we are here at the duty to the court situation. Is there anything that you're aware of that could invoke?
There is a liquidated damages. The closest I can come to think about it, there's a liquidated damages provision in the law of damages and remedies, which does say that in the event that the liquidated damages sum is out of proportion, I forget the exact words, to the sum claimed, the court may reduce it. In other words, liquidated damages sums are recoverable up to a point. And I wondered if that was analogous to a contractual interest provision. It seemed to me, if so, only very tenuously.
That is an effective attempt at reflecting the English law, which is a quite different area.
but otherwise, no. It wasn't clear to me what jurisdictional basis there was to award this, to interfere with the contractual bargain at all. But even if there was an 18% rate in the event of somebody defaulting on sums owed, in my submission, is just manifestly not an excessive one.
All right, let us then move on. I think we can say that that has been dealt with.
We touched briefly on the civil procedure law point about possession. I don't think we need to. I think the indication was we didn't need to look at that further. That's the point that's made in paragraphs 30 to 32 of the defence.
That is correct. We did not
in which case, I think that deals with the position, certainly as regards the first and second defendants, in terms of the sum and the entitlement to contractual interest and an order for possession of the vehicles. I've taken your honour to the position about our entitlement to contractual entitlement to costs of these proceedings, but I was proposing to deal with costs at the end.
Yes, yes.
Sorry.
We'll look at that when we look at
the. I just flagged the point that that's strictly something we're seeking as a matter of contract in the first instance, rather than as a matter of the court's discretion. That then raises the question of the personal guarantee.
Yeah.
And it's dealt with in the defence very shortly, paragraphs 36 to 38.
Yeah.
That's page B43.
Well, it comes down to saying demand was required. There hasn't been demand.
Exactly.
So we've got two questions. Is it required? And if so, has it been demanded? So I think as to the second question, the answer is that unless service of the claim form, etc., is a demand, it hasn't been. No, say for a small amount.
So, well, it's $140,000 odd. So yeah, yes, small in relation to the total debt, possibly not absolutely, but the central point, I think, my easiest route to success, it would be on the is a demand required point. If we turn back up the personal guarantee, I say it's not, and I think Your Honour was looking at the 966 agreement, which starts the personal guarantee of which will be at C23. And so what I say is that 2.1, properly construed, contains three sets of obligation, three different ways in which Mr. Backey may become liable to the claimant. A is a simple contract of guarantee. Guarantees the customer's performance of his obligations, the default of which Mr. Backey has secondary liability. B, in my submission, is not qualifying or supplementing A. Sorry, not qualifying A. That is a separate undertaking which gives a route for Mr. Backey to become personally liable in the event that particular sums aren't paid and a demand is made for them. And one can see why B is
is a quite different subject matter.
Say that again.
C is a quite different subject matter.
Yes, and I was going to. I take them out of order. Indeed, C in the same things. It's a further thing he's agreeing to do. He's indemnifying, as you say, for other obligations. So you've got three separate ways that Mr. Backey can become liable to the claimant. One of which is.
That's not quite right. C is not indemnifying other obligations. It's indemnifying in case any obligation becomes unenforceable, etc.
Yes. There's three ways Mr. Backey can become liable to Caterpillar. The first of which is under a contract of guarantee. The second of which is an undertaking to become primarily liable for certain sums and for certain events. And C is an indemnity against loss and damage caused by breaches of obligations. And we'll see.
If there were not a B, would you be able to rely on A for this case?
Yes.
That troubles me, I have to say, Mr. Roscoe, because it seems to me that the reading of this is that A is the general obligation, but B then is the particular requirement in relation to paying money for a demand, which is then in line with the requirement for a demand for the quite different subject matter in C, but nonetheless it is a demand. I am troubled by this.
To develop my submission on why I say they are separate, the customer has many obligations under the loan agreements, to maintain the vehicles, to register the vehicles, etc., etc., etc. They have obligations that go beyond the simple payment of sums of money from time to time. Default of those other obligations, such as to pay money from time to time, would fall within A, but would not fall within B. And so imagine a situation where, in breach of the obligation to maintain, repair, whatever it might be, the vehicles, Mr. Backey, and which causes loss and damage, Mr. Backey would be liable under the simple contract of guarantee under A, but B wouldn't bite at all, because we wouldn't be complaining about the failure to pay a sum when due. B only bites or is engaged at all where there is a failure to pay a sum and then a demand is made.
It's an occasion which is also within A.
Sorry?
Which is something which is also within A.
Yes. So in terms of a Venn diagram, A covers a broader scope of things than B.
So just let me to explain my difficulty. You don't need B at all. So what is B there for?
One doesn't need B, but B adds a further layer of protection. So, for example, B, because A is a secondary liability, the contract guarantee is secondary liability, it depends upon the customer also being liable. B, if the customer doesn't pay and a demand is made, then Mr. Backey is liable. And even if for some reason or another the customer ceased to be liable under A, B would still impose a primary obligation as on Mr. Backey, not as a guarantor of A's outstanding obligations, but as a freestanding contractual obligation to pay sums when demanded, if they're outstanding when demanded.
I don't see any occasion for B operating if the customer ceases to be liable any longer. It doesn't say that. And if the customer does not pay any amount when due, that must involve that it remains due at the time the demand is made.
Well, the first part of the clause before the comma is the condition of when a demand may be made. When it is due under or in connection with the agreement. And if a demand is made when that is extant, the guarantor shall immediately be obliged to pay it on demand and can be sued for breach of that obligation. And so the cause of action there isn't a cause of action under a guarantee, contract of guarantee. It's a claim for failure to pay contractual sum due.
Well, but it is not a. Guarantees often have primary obligation clauses.
Indeed.
This does not. Your submission really amounts to B being effectively a primary obligation clause.
Indeed.
It really doesn't say that. Because, amongst other things, it must be an amount due from the customer. Primary obligation clauses say you are liable. I will pay even if the customer isn't liable.
Well, but in my submission, properly construed, that's effectively where B goes. So, on day one, the customer has not paid an amount when due and owing. If that is the case on day one, and there is a demand on day two, then the guarantor is liable to pay on day two, irrespective of what happens on days 3 and following. Because in breach,
I just cannot see it that way. I'm sorry, Mr. Roscoe. What I am prepared to do, although every agreement depends on its own terms, is to give you the opportunity to see if you can find some equivalent clauses that might help me to change my mind in the authorities.
The reason I'm not sure that would be a particularly fruitful task is that the personal guarantee is a UAE law agreement.
Yes, but words mean the same in the UAE as they do in England, don't they?
Well, yes, I'm sure they do. Yes.
Yeah, at least English words do. Yeah.
Yes. I'm very grateful that. Let's see. I mean, yes. I mean that. If you're not persuaded, then I'd obviously be grateful for the opportunity to persuade, and I'm grateful for that. The fallback position is the partial fallback position, as it were, of the partial demand as to the see the sum here was to the sum of $175,000 odd, and that's at page A50 and following.
But you're not interested in that, are you? Surely you want everything.
Well, no.
Or maybe as a practical reality, that's all you would ever get anyway.
That might well be right. And so if Your Honour's not persuaded by me now or the fruits of further research, I would ask for that as a fallback position, because there's that, and then there is the third point, which is that as a matter of procedure, case management looking forward, if all that is required is a demand, in my submission, the bringing of the claim was a demand. There's no personal guarantee, does not require any particular form of demand or notice or anything of the sort. So the bringing of the re-amended claim was a demand for the amount.
I have no trouble with that. But there is as you have anticipated, there's still a further question mark.
Which is, given that is the case, what would be required to perfect the cause of action would be a re-amendment to the claim form and/or an amendment to particulars of claim, which added a further line to say, and this was demanded by the earlier pleading when served.
I'm not sure that's right. Here we're in the territory, aren't we, of the old law from Eshelby and the something or other, Eshelby's case.
So the line.
The old law stemming from Eshelby's case. Any amendment relates back to the commencement of the proceedings. That is the old law. That is why, if you amend it to allege a demand after the commencement of the proceedings, it would relate back and would not complete the cause of action. That's a standard problem with, or was a standard problem with guarantees.
Now, I cited the United Trust Bank case,
yeah,
which dealt with this, and that's at page K20.
Now that may provide an answer for you, but it seems to turn on the English rules, which are somewhat delicately referred to.
Abolishing the doctrine of relation back.
Well, that seems to be the implication. Now, just so we can have to be on the same wavelength, in New South Wales, which is my former territory, legislation has actually adopted it. It says by legislation that you can amend, and the amendment will be effective and will operate from the date of the amendment.
Yeah.
So if you amend it to allege a demand, if you amend it on day 2 to allege a demand on day 1, that would be effective. Question, do the English rules say much the same? Because if that is so, then your reliance on United Trust will help you. And I'm not familiar with the English rules, so again, I need your...
Certainly, the doctrine of relation back does apply under the English rules, and it's a problem and it crops up for the purpose of limitation. And so the reason that one won't get permission to amend to bring a new claim after the expiry of a limitation period is because the doctrine of relation back would bring you within limitation when by rights you're not.
Yeah.
And so it's not right to say there's a matter of English law, amendments only take effect from the date on which they're made. Doctrine of relation back does apply.
Can we perhaps try and advance this if I ask you to look at paragraph 44 of United Trust?
Yes, I was guessing there myself.
This represents, as it were, the extent of my knowledge of the English rules, which is not much. Where it is said, tell me when you get there.
Yes, I'm there. Yes, yes.
In paragraph 24, referring to Henry, who said the scope of the rules had changed since Eshelby.
Yes.
And to general discretion. Now, unfortunately, I do not know what lies behind that.
No,
The difficulty may be, just to advance it, that I can't see anything in the DIFC rules that might do the same.
Let me just turn up in my white book, part 17, which deals with our amendments. And I think what might underpin this is the limitation point, because what is said at 17.4, as I alluded to, is that in the case where a party applies to amend his statement of case after a period of limitation has expired, the court may allow an amendment to add or substitute a new claim only if the new claim arises out of the same facts or substantially the same facts. And so I wonder if what Lord Justice Mance there is talking about is that, but I'm not afraid I'm not sure that's a complete, if very helpful answer. We certainly.
Can I interrupt? I don't think that can be it, because that is consistent with the new cause of action subject to the limitation period, nonetheless being complete prior to the commencement of the proceedings. The trouble is that it might be complete by statute barred, and that's what that rule deals with.
Yes.
So we need something else. But the biggest problem is that whatever it is, and one should try and find out what it is in order to understand, there may be nothing the same in the DIFC court rules.
I entirely see the point you want to make, and the further point, I suppose, that whichever it is a further step that's going to need to be taken.
Well, the United Trust case seems to say that, well, you don't actually need to take the step. We'll somehow allow it to happen without the formality of taking the step. But nonetheless, it's got to be a step which could have been taken.
Yes. No, I entirely see the point. And again, I'm, to my embarrassment, my apology, I don't think I'm in a position here to deal with that point of difference, though I understand it, and at the risk of seeking more indulgence than I should be entitled, or adding unduly to my homework, I wonder if that is a further point on which I might add to the list of supplemental.
Yes, indeed. I think that is entirely appropriate. This is very important because the claim against the guarantor really substantially depends on this.
Yes. Yes. And so the question really, for Your Honour, boils down to: is it simply a matter of effectively case management discretion? Look, we can regularise it as a matter of simply of case management procedure, treat as demand being made, and whether or not one needs to be made.
No, I'm sorry, it's not case management. It's whether Eshelby is still.
No, exactly. So, depending on the answer to that question, will depend on whether there is a substantive bar to it being dealt with as cash case management or not.
Yeah. Well, again, I'm not too sure it's case management. Dealt with in accordance with the way the United Bank dealt with it.
Yes.
In the exercise of some sort of power. With the greatest respect, I'm not entirely sure what sort of power they were exercising there, but whatever it is, they say it's there.
Yes, I think the power they were exercising was the power to case management powers. I think it's probably a combination of the saving provision and case management powers, isn't it? Which failure to take a step doesn't invalidate the proceedings. You fail to do this, so we'll look at it.
No, I think at best it was to dispense with procedure. We will dispense with the procedural step of applying to amend.
Yes,
that's really
so short circuit. Was it maximum actually? Look has done that which ought to have been done, or something like that to put in a slightly different context. May I then add that to my?
Yes, I think there are
homework today.
Yes. Now let's just go back. We need to look at the relief you're asking for, but the three things are in reverse order. One, some investigation of what lies behind the scope changes in the scope of the rules which disapplies as referred to in United Trust Bank.
Yeah.
And whether it is operative under the DIFC court rules. I think that probably proves the point. The second is the validity and or qualification of the conclusive evidence clause in the agreement.
Yes.
And the third
was whether or not there are other cases which might shed light on the primary obliger nature of 2.1b or whatever it was,
which might persuade me that my current thinking is wrong.
Right. Yes, I've got a note of those. I will in your honour's hand as to how swiftly you would like the
well, I don't think time is not a huge factor. I don't think. What time would you like to do a proper job of it?
Would a week be too indulgent?
A week would be fine. Well, let me be frank. As from the end of next week, I'm going to be actually away doing something else and not thinking about the law at all for about 2 weeks. So if you want to take a bit longer, you can.
I'm both envious and grateful. Thank you.
Yeah. So let's say there should be a time. So let us say within 2 weeks.
Going back then to the relief, which might be certainly as regards the first and second defendants, the draft order is at A37.
Yes. I have a printout which I've got from somewhere else. It has orders 1, 2 down to 9, liberty to apply. Is that
That's
right?
right, yes.
Yes, I have that.
Thank you. So the 2A is the principal sum.
Yeah.
2B is interest calculated there to the default interest calculated 7th of November 2021, and increasing today. I think I'd done the sum to today in the in my skeleton argument.
Yes. Yes. Well, the 3 is really addresses post-judgment interest, and what that amounts to is asking that post-judgment interest in the exercise of the court's discretion, which PD4 gives, should be at the contractual rate. That's what it amounts to, isn't it?
I suppose one might also describe it as a specific performance, but I think the way, the simpler way is probably the way Your Honour puts it, yes.
Well, my understanding is that that's normal, to be honest.
Yes.
I don't have a problem with that.
4 then seeks the order for possession of the vehicles by reference to their registration number, for ease of reference, and to transfer the registrational title to the security agent in accordance with the obligations under the terms and conditions to cooperate in that respect.
Yep.
5 is making express that which really ought to be obvious, but the point was made in the defence as to the concern about double recovery if we were to get an order for money and be able to sell the vehicles.
Yes. Sorry, just let me check one thing, if you don't mind.
Yes.
The mortgage is in fact to Al Bahar, isn't it?
As security agent.
As security, yes, I see. So where paragraph 5, order 5, says the claimant shall be entitled to sell, that would effectively be the claimant by its agent.
Yes, correct. Yes, yeah, you can make that amend.
Yes, I think it might be wise to include that.
Thank you. Then 6 is cost, to which there's a contractual entitlement, and the cost schedule is at page M1 and following, section M.
Now, is that cost schedule proof of costs? It usually has a different form. Has a different function under the rules. It's kind of a saying, this is what I'd like. And then the judge makes a summary assessment. Do I need proof of costs?
It is verified by a statement of truth confirming the accuracy of the figures. That's at page M3.
Okay, now that may be good enough, because I think under the rules that's am I not really concerned with the costs actually charged to Caterpillar?
Sure.
Do I need proof that these are the costs that have been or will be charged? So strict in the ordinary course, in other jurisdictions, I would not have a statement of costs. I would have an affidavit which said the amount charged to the plaintiff is X dollars, being the bills of costs submitted A, B, and C, and the further amount which has not yet been charged but is made up of this, and this, and this, the further sum. That's what I'd ordinarily have.
Well, I think this is more modelled on the English way of doing it, which is where a statement of costs is put in as the evidence of the costs, and if not expressed, then certainly implied that doesn't put in a schedule of costs for more than is in fact due.
I must confess that I was not aware of the English practice, but this is in fact the English practice.
This is the English practice, putting a schedule of costs.
Right.
I might just pull up to see if I can I don't know if the statement of the schedule of truth. Actually, so our schedule of truth has the further bell and whistle that it confirms that that the signatory believes that is a reasonable sum for the claimant to have spent on it as well for the purpose of summary assessment. But this mirrors the English practice. As Your Honour says, it's the usual function of it is for a summary assessment.
Yes.
But the foundation of it is to give the evidence of what the top level figure is from which the assessment is made. So it does stand as evidence of what the figure is.
Yes. You know, I think you are drawing my attention to the statement of belief. I think that does make a difference. I did not have in my mind that was there, and under the rules that can stand as evidence. So that's all right. Okay, so we've got that for
Grateful.
6.
And then 7 is records the further indemnity under the agreements. Whether that extends to the third defendant as well is obviously still up for grabs.
Well, I'm reluctant, prima facie, to make an order in the terms of Order 7, because that seems to be an order for specific performance of something that we don't know anything about in the future. Seems to me you would be entitled, if necessary, to a declaration that the defendants are obliged to identify the claim. But I don't know about casting it in the terms of an order for performance.
I don't think I would push back against the changing that from a statement of an order of indemnity to a statement of declaration.
And I haven't checked the terms of Order 7, but it should reflect whatever the relevant terms are in the agreement.
Yes, I'll double check that. Thank you, Your Honour. To a degree, in the court's hands on this, but I think without formally checking instructions, I think I know what my client's position is likely to be. Whether or not Your Honour wishes to hold over making the order on everything, or whether or not You're prepared to make the order as regards the first and second defendants now, and hold over decision or judgment as regards the third. I think
I'd like to hold over everything, and I think I need to do it because you are going to tell me whether you want to enter into the conclusive evidence clause or not, which is relevant to the first and second defendants.
Thank you. Thank you. In which case, I think that's everything I need to raise today. I thank you again for the indulgence, giving me the opportunity to follow up those points. I will do so.
Yes, well, I'm sorry to have created difficulties, but
No,
I must be very careful, in particular when the defendants are not present, to make sure that their position is carefully considered.
I'm grateful, Your Honour.
Well then,
is there any particular channel those should be submitted? Presumably, they'll be filed with the registry, the further documents in the ordinary manner.
yes, and the registry will pass them through to me. Let us leave it on the basis that, subject to anything you may particularly want to say in them, and include whether you want me to deal with conclusive evidence or not. Subject to anything in particular you might say, let's leave it on the basis that I will take on board your further submissions and I will give judgment unless either you ask for another hearing in your piece of paper or I feel the need for it, in which case I will say so and something can be arranged. But subject to either of us saying that, I'll proceed to give judgment, which conceivably, if I'm not persuaded for for example, demand could not be as full as you would like.
That's understood. Thank you, Your Honour.
All right. Well, I think that brings us to an end for the day. Thank you very much for your assistance. I greatly appreciate it, and look forward to what is to come.
Thank you. Bye.
Thank you. Okay, good. I'll adjourn now.